I would like to invite Ms. Anoosha Shaigan, who has an expertise in IT and law in particular, and who has uh, made presentations on information technology and e-courts to justice sector institutions. She is currently Vice President of Courting Law, and she has vast experience in litigation and policy reform as well. Ms. Shaigan, thank you for being with us. And if you could just guide us on the possibility of having nationwide e-litigation and the benefits it entails. Thank you.
As we all understand, our legal and judicial process is complex, it's slow, and it's expensive. And that's how, and that is why essentially we are trying to look for better means in order to streamline the process. And we want to do this not just for ourselves, but for the adjudicators as well as the end users who are the litigants essentially. So we work in digitalizing human rights, and one of which is, of course, access to justice. And whatever we do, our ultimate goal is to benefit the ultimate consumer. In the process, of course, we as lawyers want to benefit from it as well. But just to give you an example to sort of reiterate this, so there's this company called Black & Decker. It makes power drills. And I don't know, you might have heard of this story before, but what they do when they hire new employees is they ask all their new hires to, they give them a power drill, and they ask them, how do you want to sell this? How will you go about selling this, and what are the good things about this, and how will you make sure consumers use it? And of course, a lot of people come up with all these ideas and marketing techniques and whatnot, but at the end of the day, what they tell their employees is that nobody cares about the drill. The consumers don't care about it. What they actually do care about is the hole in the wall. So our ultimate goal is to find that hole in the wall, which is access to justice, which is the promotion of legal services, which is bridging the gap between what the litigants want and what is being delivered to them as a public service, which is justice essentially. They do not care about how we go about doing it. They couldn't care less about how much funds we have and how many platforms we're making and how many apps we're making. Of course, it obviously benefits them and facilitates them. They don't care how we go about doing it. So they do not care about the power drill, which is what we are in the business of essentially, and what we're talking about. They only care about that hole in the wall, and we have to make sure that they find it through whatever we're doing. So getting that out of the way first. Now, we talk a lot about litigation and ADR. Now, a lot of lawyers understand this as two very separate processes. So if you say litigation, they would automatically assume that it's something that has to do with the court as a building where you go to find this and go through all the legal processes. And if you say ADR, they think of it as something that that's sort of like an out-of-court settlement, and that's something that does not involve maybe going to court. So lawyers tend to make a very sort of like a black and white distinction between the two, and I feel like it does not have to be that way. We can always look for a more blended approach. And that's why we have ODR mechanisms as well. ODR, ADR, CADR. So ODR is, of course, online dispute resolution. CADR is consumer alternative dispute resolution, which involves arbitration and all the other processes as well. And OADR is online alternative dispute resolution. So, it can happen in e-commerce cases, and that's where it essentially comes from. Basically, it is being used in commercial disputes relating to insurance and a few banking transactions, for example. And ODR is also being used for domain name disputes. So when you register a website and there's an issue with the domain name registration and whatnot, you can, there's a fairly straightforward online process. Maybe not to the layperson, but for the technical people, they can resolve this online. So e-commerce and domain name disputes are the primary focus of ODR tools and mechanisms at the moment, but obviously it needs to expand to other areas as well. For example, the justice system essentially and litigation. So now there are a lot of tools that we can use. Just so many approaches that we can use. There's obviously, as far as ADR is concerned, it can obviously be translated into ODR mechanisms, and you have your negotiations, and then you have your identification of problems and framing of issues and technology-assisted negotiations, and then you can even have online arbitration. So like a lot of countries are, I wouldn't say a lot, but a few countries are, focusing on developing different aspects as far as, their legal systems are concerned. So as far as we are concerned, we obviously, we have video conferencing. That gets one thing out of the way. But video conferencing is not the entire IT system. It's only one aspect of it, and it's only a medium. So, we can even send out, now the litigation process or the court process involves different stages, right? So you have to send notices to the parties. That can be done through online platforms as well. Usme sirf ye cheez aa jati hai that you have to ensure that the person that you're sending a notice out to has actually received it. So proof of receipt is important, and tech tools and digital tools have been able to, sort of ensure that. Now, that WhatsApp is not the answer to that. Our courts are mistaken in saying that this can be done through WhatsApp. You cannot ask people to download a certain app and be available online. That's just not how anybody's individual rights would work. Obviously, there can be QR codes. So for example, if you send somebody an email or an SMS, you can attach a QR code next to it, so that if somebody has read it, the sender would be able to find out that they actually did receive it and open it. So, these are the kind of tools that are available. When it comes to online negotiations and deliberations, obviously video conferencing, you already have it. And the Judicial Academy in Punjab has also, they've installed cameras and whatnot. We, of course, have online publishing and reporting of judgments. So, we're not unfamiliar with that concept either. The Lahore High Court and the Supreme Court, I think they both have their research centers and they can publish judgments. And but ensuring that it's not a public judgment and it's only delivered to a certain party would, of course, require certain encryption tools and, online identification, and make sure you're sending it to the right person only. So digital tools can ensure that. Now, what we don't have at the moment is the e-filing system. So we have notices, we have video conferencing, we have judgments and whatnot. We do not have a proper e-filing system at the moment. That essentially requires people getting on the internet, uploading their documents to be sent to the court, and then court giving them a date of hearing and, asking for evidence and options to upload evidence and your identity documentation, as well as a payment system. So e-filing system is not available at the moment, and that is something that should be mainstreamed with the help of tech companies, of course. But like I said, these tech tools are not that technical that we keep fretting about them. So when we say IT, we do not have to fear technology in any way. These are very straightforward and simple processes, and they have to be simple in order for the users to understand them. So जितना ज़्यादा उसको आसान रखेंगे, उतना ही ज़्यादा वो यूजर फ्रेंडली रहेगा, और जो litigants हैं, जो end users हैं, वो उसको इस्तेमाल करेंगे. So we do not have to fear technology. These are fairly straightforward processes. We just have to make sure that whatever legal requirements we have, they comply with those, and that at the end of the day, they are based on human-centered design, which means that they are made for the people. They're not made, the problem with legal design is that the organization putting it out designs and develops them according to their own preference and from their perspective. However, you have to do it from the perspective of the litigant. So these are some of the things that I just want to get out there. Of course, if you want to go into the minutiae of the processes and all the small details, I can do that as well, maybe later in the conversation. But these are some of the things that are should set a good stage for the conversation further. And as far as having best practices and different models to look at is concerned, obviously, we can take examples from many countries such as China, such as the UAE, such as Singapore, the European market, and the WTO itself. So they have very good online dispute resolution mechanisms, and they apply to different areas. So for example, something that is working well for civil disputes may not be the best for criminal disputes, for example. So it's, at the end of the day, it's just about making the right combination of the right tech tools and digital tools and the right platforms.
Yes. And Ms. Shaigan has already been very proactive in advocating for data security because she has worked on this specific aspect, especially in terms of regulating the data and how much security should be attached to it, because of course this is very important data. So Ms. Shaigan, if you could just pick up from where Dr. Saab left off.
Right, thank you. So thank you for listening so intently to my conversation earlier. You picked up all of the points. I'm very impressed. So just to add to these things, I mean, we have lawyers on board and we have tech people on board, and my job sort of combines both. So I'm a legal technologist. So when somebody gives me an AI-based solution, if I'm a lawyer, you know, I'd be very mesmerized by it. I'd be maybe a little fearful about it. I'd be willing to pay a lot of money for it or not at all. But my job as a legal technologist is to obviously point out the legalities of these tech tools and technologies as well. So for example, if we're using AI, somebody in my position should be able to identify exactly which AI tool would be used for which particular process. Now, as far as the legalities are concerned, when it comes to civil claims and small claims, disputes involving small amounts, AI is an excellent tool according to the studies because it can use a predictive algorithm in determining what kind of money you're looking at, what kind of timelines a user is looking at. And it also works when it comes to precedents. So when you are sure that judges are going to apply precedent, then AI and algorithms can obviously facilitate that and automatize that job for them. However, it may not work well in criminal cases because the person's liberty and life and death is at stake. So in those cases, maybe algorithmic bias may come in, and maybe this technology may not be the best solution in that particular kind of case. Or, for example, in cases involving very high amounts where, you know, you actually do need a neutral third party or a human with wisdom to actually rule on these things. So, you know, it at the end of the day, it is about making the right kind of combination. Now, just to give an example from this parole board hearing study in Israel. So what the study found out was that judges were giving at least 30% harsher sentences 1 hour before and after the lunch break as compared to the morning docket timings. So these are the kind of, now technology and algorithms and AI can obviously, you know, completely remove that bias and completely remove, they're not going to get tired or hungry, right? So they can be used in these kind of situations. But then again, it ultimately depends on which particular microprocess or which particular stage of the case management you are in order to be able to sort of deploy these tools. I noticed there was a lot of talk about frivolous litigation. So if we do, because I've done a deep dive into ODR systems in particular, I can say for sure that if we were to adopt certain ODR models from different countries, as Ms. Hamid said, we do not have to reinvent the wheel. And when we adopt these models, they do come with their own certain standard operating procedures or SOPs. So when it comes to frivolous litigation, most of the ODR mechanisms already have clauses in place for forum shopping, which means that you cannot simply just pick and choose whether you want to have a blended approach, whether you want to go for negotiation, you also want to file a case in court, and you also want a person to be present there, which just increases costs. So forum shopping is a very particular clause mentioned within ODR systems that discourages this kind of frivolous litigation and actually penalizes the parties, or at least discourages them in some way that they're not supposed to be doing this in order to waste the court's time and resources, or their own resources, for example. So if we were to do a deep dive in these ODR models, we would find that we actually do not have to reinvent the wheel, and some of the standard operating procedures are actually quite helpful, and we can just use a sort of like a plug and play approach and try to see what works for us. Then there, of course, like I mentioned earlier, lawyers tend to draw very strict boundaries between litigation and ADR. If they're litigators, they're not arbitrators or mediators. But when we talk about e-litigation and online dispute resolution, we have to take the best practices from the ADR system. The online litigation system or the e-litigation system is not going to work without taking best practices from the ADR system. So it has to be, very important. As far as training procedures are concerned, of course, you can train judges and lawyers all you want, but then again, it can get a little overwhelming because we know our judges have to be of a certain age, right? They are not tech-savvy people to begin with, perhaps. Maybe not the younger judges, but judges have to be of a certain age, so you have to give them that leeway of not being familiar with everything that exists in our digital ecosystem today. So we don't want to overwhelm them with all the trainings and capacity building, upskilling, reskilling, all these buzzwords. We don't want to overwhelm them with that also. They can, of course, have they can refer to judicial academies, they can have clerks, they can have research associates assisting them. They should be able to be self-sufficient in conducting enough research that is required, but we shouldn't expect them to know everything from A to Z, or the whole process throughout. So that is something that I wanted to get in. And as far as lawyers being replaced by technology is concerned, if their jobs are automatized, do they fear being replaced? Of course they do. And that's when we conducted the study on e-courts, that was one of the main fears that we discovered amongst lawyers. So, but the idea is in this day and age, automatization of these repetitive jobs is an inconsequential is an unfortunate consequence. It is inevitable. It is going to happen, and if we don't pivot or reskill or upskill our own selves, then we are going to lose out essentially. So we really have to encourage lawyers to make sure that they're still involved in the process. In other capacities. Of course, the system cannot function without a lawyer. A lawyer is supposed to be a person's agent and representative within the case management process, and we can't do away with them altogether. We're just trying to automatize the repetitive jobs that don't require a lot of wisdom on their part. And that essentially is what the clients want at the end of the day. They want lower costs, they want less human interaction perhaps, but they do also want hand-holding at some point. So we can't really get rid of them, completely altogether. Other than that, in order to encourage the public to use online platforms, now studies have shown that what the government and what the judiciary sees these processes is, how they see it is that they want to give credibility to these apps and platforms, and they want to give them funding, they want to get them registered, they want to give them as much credibility as possible so that the people feel comfortable. However, studies have shown that people are actually more comfortable using online platforms, not because of the credibility or the government backing that they come with, but because of the presence and availability of accountability mechanisms. That in case something goes wrong, how will they manage their dispute then? In case, for example, if it's an electronic transaction, in case they lose their money, how are they going to get it back? In case they need any technical assistance or somebody to guide them on the processes, who is going to be there to support them or advise them of the things? So credibility is good, but accountability mechanisms have to be embedded within these systems, to begin with, in order for people to be able to use these systems more comfortably. And at the end of the day, it's as far as training is concerned, you can teach them all about using technological tools. You can guide them. You can make as many user-friendly platforms as possible. But the people working within the judicial sector, they have to be very solid on their legal fundamentals also. So for example, they have to know what constitutes a contract. They have to know their constitution. They have to know their commercial commercial law provisions. So without that foundational fundamental knowledge, whatever you teach them on top of that, it can work, it may or may not work, but their fundamentals really have to be strong in order to be able to use these platforms. Now, like I said earlier, a court passed a judgment that WhatsApp was an okay platform to send out notices, and you can't really ensure that somebody has actually read the message on WhatsApp, because you don't know what kind of device they're using, what part of the country they're in, whether they have their privacy settings on, which shows that they've actually read a message. So it's a lot of assumptions that the court made when passing that judgment, and that was maybe not the best or the most ideal of things to do. So, technology can, of course, provide us with options. And for example, we established this platform where lawyers would advise people on how to go about their legal processes, and women simply refused to post their queries because of confidentiality and privacy matters, and we couldn't figure out what to how to get them to be more engaged in the process. So then we asked our technical expert, and he just gave us an option, maybe you want to put an anonymous feature in your platform. And we weren't aware that we could do that. This is at least, I think, 6 years ago. We weren't aware at all that we could do that. We did not want to leave everything to social media or make Facebook groups and whatnot. We wanted to have a dedicated platform for these kind of things. So these are the kind of things, if you are, as a lawyer, have done your research and have identified your bottlenecks, only then will a technical person will be able to assist you better and provide you with all the options. So like I said, we really have to do a deep dive into these systems so that our communications with each other are clear, and ultimately the user is going to benefit from that.